I'm attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series discussing mergers and acquisitions. Today I will continue my discussion on the responsibilities of the board of directors and in particular their fiduciary duties related to merger and acquisition transactions. In the last LawCast in the series, I highlighted the duties of the directors, including the overall duty of honesty and good faith, as well as the duty of care, duty of loyalty, and duty of disclosure. I also outlined the business judgment rule, enhanced scrutiny business judgment rule, and the entire fairness standard. As with many aspects of securities law and the law in general, a director's responsibilities and obligations in the face of a merger or acquisition transaction depend on the facts and circumstances. From a high level, if a transaction is not material or only marginally material to the company, the level of involvement and scrutiny facing the board of directors is reduced and only the basic business judgment rule will apply. For instance, in cases where a company's growth strategy is acquisition-based, the board of directors may set out the strategy and parameters for potential target acquisitions, but leave the completion of the transactions largely with the C-suite executives and officers. The director's responsibilities must take into account whether they are on the buy or sell side of a transaction. When on the buy side, the considerations include getting the best price and deal for the company and integration of products, services, staff, and processes. On the other hand, when on the sell side, the primary objective is maximizing the return to shareholders, though social considerations such as job loss may be considered in the process. The law focuses on the process. I talked about that in the last LawCast and I can't stress it enough. The process, including the steps and considerations made by the board of directors, are more important than the final decision even. The greater the due diligence and effort put into the process, the better, both for the company and its shareholders and for the protection of the directors in the face of scrutiny, including dissenters' rights actions, which I'll talk about in a future LawCast in this very same series. Boards will consider facts such as attendance at meetings, the number and frequency of meetings, knowledge of the subject matter, time spent deliberating, advice and counsel sought by third-party experts, requests for information from management, and requests for and review of documents and contracts. In the performance of their obligations and fiduciary responsibilities, a board of directors may and should seek the advice and counsel of third parties, such as attorneys, investment bankers, and valuation experts. It is generally considered good practice to obtain a third-party fairness opinion in a transaction. Most investment banking houses that do M&A work also provide fairness opinions, and they'll provide them whether or not they're actually involved in the transaction. In addition to adding a layer of protection to the board of directors, the fairness opinion will be utilized by accountants and auditors in determining or supporting valuation for the transaction, especially when there's a related party involved. This firm has relationships with many firms that provide such opinions, and we always encourage our clients to utilize the services. In the next LawCast in this series, I will continue to discuss the duties of the board of directors and start to highlight Delaware case law on the subject. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's LawCast, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.